If you're navigating the U.S. immigration system right now, checking your application status daily, or waiting for news about your visa or green card, what I'm about to share with you is critically important for understanding exactly where things stand as we begin 2026. The immigration landscape has shifted dramatically in recent weeks, and whether you're inside the United States or abroad, these changes are already affecting processing times, application reviews, and visa issuance across multiple categories. This isn't speculation or rumor. These are official policy changes that went into effect on January 1st, and understanding them clearly will help you make informed decisions about your immigration journey moving forward. Welcome back. If you're new here, make sure to subscribe and turn on notifications because immigration policy can change rapidly, and staying informed is absolutely essential. Today, we need to talk honestly about what's happening with U.S. immigration in January 2026, because the reality is complex and affects different groups in different ways. Some of you will find relief in certain areas, while others are facing new challenges that require immediate attention and careful planning. Let's start with the most significant development that took effect on January 1st. Presidential Proclamation 100998 expanded travel restrictions to 39 countries, with 19 countries facing full suspension of visa issuance for both immigrant and non-immigrant categories, and 20 countries under partial restrictions. The countries under full entry bans include Afghanistan, Burma, Burkina Faso, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Laos, Libya, Mali, Niger, Sierra Leone, Somalia, South Sudan, Sudan, Syria, and Yemen, plus individuals using Palestinian Authority travel documents. Countries facing partial restrictions include Angola, Antigua and Barbuda, Benin, Burundi, Côte d'Ivoire, Cuba, Dominica, Gabon, the Gambia, Malawi, Mauritania, Nigeria, Senegal, Tanzania, Togo, Tonga, Venezuela, Zambia, and Zimbabwe. If you're from one of these countries, this directly impacts your ability to obtain visas or enter the United States, though there are limited exceptions for certain categories. Now here's something critically important that many people aren't fully aware of yet. USCIS issued a policy memorandum on January 1st, directing personnel to place a hold on all pending benefit applications for individuals from countries listed in Presidential Proclamation 10998, and to conduct comprehensive reviews of all applications from these countries approved on or after January 20th, 2021. This means if you're from one of the designated countries and you have a pending application with USCIS for a work permit, a green card, a visa extension, or any other immigration benefit, your case is likely being held at the final adjudication stage. Your application can be processed up to the point of decision, meaning you might still receive requests for evidence or notices of intent to deny, but the final approval is being held pending additional security reviews. Even if your case is otherwise approvable, you may face significant delays until USCIS lifts the hold. The re-review policy is equally significant. Cases approved on or after January 20, 2021 may be reopened for additional screening, interviews, and re-interviews, even if benefits were already granted. This creates uncertainty for individuals who thought their immigration matters were resolved. If you received approval for a benefit in recent years and you're from a designated country, you should be prepared for the possibility of additional requests from USCIS. But this isn't the only major change. The Trump administration announced a pause on immigrant visa processing for nationals of 75 countries starting January 21, affecting family-based and employment-based immigrant visas processed abroad. This suspension doesn't affect tourist, student, or business visas, but for families waiting to reunite or employees waiting for green cards through consular processing, this represents a significant setback. Countries affected include major nations like Brazil, Colombia, Egypt, Nigeria, and Russia, among many others. State Department officials indicated the suspension will remain in place while screening procedures are reviewed, but no timeline has been provided for when processing might resume. For those of you waiting for green cards or tracking visa bulletin movement, there's a mix of news. USCIS continues to allow applicants to use the dates for filing chart for both family-sponsored and employment-based categories in January 2026, which does provide some forward movement for people whose priority dates have become current. However, the broader restrictions mean that even when priority dates advance, individuals from affected countries face additional hurdles in actually receiving their visas or final approvals. Let me address work authorization, because this affects thousands of people who depend on employment authorization documents to support themselves and their families legally. USCIS announced on December 4th that it reduced the maximum validity period for certain employment authorization documents to 18 months. This doesn't eliminate work authorization, but it does mean more frequent renewals, more fees, and greater administrative burden on both applicants and their employers. The shorter validity periods require extremely careful attention to renewal timelines. If you're relying on an EAD, you need to calendar your renewal date and file well in advance, ideally 120 to 150 days before expiration, to avoid gaps in your ability to work legally. There's also important news about vetting and screening procedures that will affect how applications are processed moving forward. USCIS established a new vetting center in Atlanta, Georgia, to serve as the primary hub for advanced background checks and supplemental reviews of immigration applications, leveraging classified and non-classified screening capabilities, including artificial intelligence. This center will conduct enhanced screening for individuals who may pose security concerns, have criminal histories, or have committed fraud. While this is positioned as a security measure, it practically means longer processing times and more intensive scrutiny for applications across multiple categories. The State Department has also expanded its online presence review requirements. On December 3rd, the State Department announced expansion of social media screening to include H-1B workers and H-4 dependents, requiring applicants to disclose social media identifiers and ensure accounts are set to public visibility during visa adjudication. Previously, this screening applied mainly to student and exchange visitor categories. But now, employment-based visa applicants face the same requirements. If you're applying for an H-1B visa, or your family members are applying for H-4 status, you need to be prepared to provide complete social media information and understand that your online presence will be reviewed as part of the vetting process. Now let's talk about something that will affect many people planning international travel. If you're a foreign national with pending immigration benefits, or if you hold temporary status in the United States and you're from one of the designated countries, international travel has become significantly riskier. Even if you have a valid visa, the expanded vetting procedures and travel restrictions mean you could face enhanced scrutiny, longer processing times, or potential difficulties re-entering the United States. Immigration attorneys are strongly advising clients to postpone non-essential international travel, particularly during the early months of 2026, while these new policies are being implemented and their full impact becomes clear. For those of you who use premium processing to expedite your applications, there's a fee increase coming. Effective March 1, 2026, premium processing fees will increase, with Form I-129 non-immigrant worker petitions and Form I-140 immigrant petitions both increasing to $2,965. This represents an inflation adjustment, and while the fees are going up, the service itself remains available for eligible categories. If you're planning to file with premium processing and your timeline allows, filing before March 1st will save you money. However, for nationals of restricted countries, premium processing may not overcome the adjudication holds currently in place. There's also significant news affecting diversity visa winners. On December 18th, the Department of Homeland Security announced a pause on the DV-1 portion of the Diversity Immigrant Visa Lottery Program, which annually allocates up to 55,000 visas. If you were selected in the Diversity Visa Lottery, this pause creates substantial uncertainty about whether you'll be able to complete your application process. The situation remains fluid, and diversity visa applicants should monitor official announcements closely for any updates or guidance. Let me be direct about what all of this means practically. If you're from one of the 39 countries under full or partial travel bans, or one of the 75 countries affected by the immigrant visa processing pause, you're facing significant obstacles right now. Applications are being held, approvals are being delayed, and previously approved benefits may be subject to re-review. This doesn't necessarily mean denials, but it absolutely means uncertainty and waiting. If you're from countries not affected by these restrictions, your processing continues more normally, though the overall immigration system is operating under heightened scrutiny and expanded vetting procedures that may affect timelines across the board. For families separated by these policies, the waiting is incredibly difficult. For workers whose employment authorization is expiring or who need renewals, the shorter validity periods create additional stress and administrative challenges. For students and professionals who need to travel internationally, the enhanced screening and potential re-entry difficulties create real complications for educational programs and career opportunities. What should you be doing right now? First, if you have any pending applications with USCIS, monitor your case status regularly through the online system and respond immediately to any requests for evidence or notices. Second, if you're planning to file new applications, consult with a qualified immigration attorney who understands these new policies and can advise you on timing and strategies specific to your situation. Third, if you have employment authorization that will expire in 2026, begin your renewal process as early as possible to minimize any gap in your ability to work legally. Fourth, if you're considering international travel and you're from an affected country, or you have pending immigration matters, seriously reconsider that travel unless absolutely necessary, and consult with legal counsel before making any decisions. The immigration system in January 2026 is operating under significantly more restrictive conditions than in previous years, with expanded travel bans, processing holds, enhanced vetting, and re-reviews of previously approved benefits. These aren't temporary disruptions. These are policy changes that will shape immigration processing for the foreseeable future. Understanding these realities clearly and planning accordingly is essential for anyone navigating the U.S. immigration system right now. That said, the system is still functioning. Applications are still being filed. Some categories continue to move forward. People who are not from restricted countries and who have complete, well-documented applications are still seeing approvals. The key is understanding exactly where you stand, what restrictions may apply to your specific situation, and what steps you can take to protect your immigration status and move your case forward to the extent possible under current policies. If you found this information helpful, please subscribe to stay updated as these policies continue to evolve. Immigration law changes rapidly, and having accurate, timely information is crucial for making good decisions. Share this with anyone in your community who might be affected by these changes. Drop a comment below about your experience or your questions, and remember that while the system is challenging right now, staying informed and working with qualified legal help when needed gives you the best chance of navigating it successfully. Thank you for watching, and I'll see you in the next update.